Understanding Trusts 101. Secure your financial future with ease. Trusts are often perceived as complex legal instruments best left to the wealthy or legally savvy. However, understanding how trusts work is essential for anyone interested in ensuring their assets are managed and distributed according to their wishes. Also, understanding trusts and estates law facilitates the conversation when discussing the topic with your estate planning attorney. Let's dive into the world of trusts, focusing on the various types of trusts, their benefits, as well as how do trusts work as an integral part of your estate planning. What are trusts? At its core, a trust is a legal contract that outlines how your assets should be handled and distributed. Think of it as a way to manage your wealth while you're alive and even after you pass away. The person creating the trust is known as the grantor, and the individuals or organizations benefiting from the trust are called beneficiaries. A trustee is appointed to manage the trust according to the terms set by the grantor. Types of trusts: testamentary and living trusts explained. There are two types of trusts: testamentary trusts and living trusts. A testamentary trust is created through a will and takes effect after the grantor's death. In contrast, a living trust is established during the grantor's lifetime. Living trusts can be further divided into revocable and irrevocable trusts. Living trusts and wills, a comparison. Living trusts are particularly popular because they offer significant advantages over other estate planning tools, such as wills. In this section of the guide to understanding trusts and estates, you will learn the reasons why a living trust might be a better choice than a will. Avoiding probate. In understanding wills and trusts and looking at their differences, one of the most significant advantages of a living trust over a will is the ability to avoid probate. Probate is the court-supervised process of validating a will and distributing the deceased person's assets. This process can be time-consuming and expensive. Overall, the probate process typically takes between 6 months to 18 months, with simpler estates leaning towards the shorter and more complex ones potentially taking longer. It can also be emotionally draining for your loved ones. A living trust, however, allows your estate to bypass probate entirely, ensuring a smoother and quicker transfer of assets to your beneficiaries. This means your family can avoid the legal fees, court costs, and delays associated with probate. Generally, transferring assets through a trust typically takes a few weeks to a few months, significantly faster than the probate process. For simple estates, the entire process of transferring assets through a trust can be completed within a month or two, while more complex estates may take a few months. Ensuring privacy. In further comparing living trusts and wills, another key benefit of a living trust is privacy. Wills become public records once they go through probate, which means anyone can access the details of your estate and the distribution of your assets. This can lead to unwanted scrutiny and potential disputes among family members or outside parties. In contrast, a living trust remains a private document, and the distribution of assets is handled confidentially by the trustee. This ensures that your financial affairs and the details of your estates remain out of the public eye. Continuous management of assets. A living trust provides continuous management of your assets, even if you become incapacitated. If you were to suffer a debilitating illness or injury, the successor trustee you appoint can step in and manage the trust's assets on your behalf. This ensures that your financial affairs are handled smoothly without the need for a court-appointed guardian or conservator. A will, on the other hand, only takes effect upon your death and does not offer any protection or management of your assets during your lifetime. Flexibility and control. A living trust offers greater flexibility and control over the distribution of your assets. You can specify detailed instructions on how and when your beneficiaries will receive their inheritance. For example, you can set conditions such as reaching a certain age, graduating from college, or achieving other milestones. This can help ensure that your assets are used responsibly and in accordance with your wishes. A will typically provides for a more straightforward distribution of assets, which might not allow for such specific or conditional distributions, reducing estate expenses. By avoiding probate, a living trust can also reduce the overall expenses associated with settling your estate. Probate fees, which include court costs, attorney fees, and executor fees, can significantly deplete the value of your estate. For example, the total costs for probating an estate valued at $200,000 can amount to $13,800, while an estate valued at $500,000 may incur costs of $36,200. On the other hand, although the costs of executing a living trust can be substantial, they are generally lower than the cumulative costs of probating a will, especially when considering the long-term savings and benefits. Setting up a living trust for a simple estate might initially cost around $2,550, with minimal ongoing expenses. For a complex estate, initial costs could be around $5,450, plus a maintenance fee, usually ranging between 0.5% and 1.5% of the trust's assets annually. A comparison of these expenses highlight the importance of considering alternative estate planning tools, such as living trusts, which can help avoid probate and preserve more of the estate's value for your loved ones. By minimizing these costs, a living trust helps preserve more of your assets for your beneficiaries. Additionally, a living trust can offer certain tax advantages, depending on its structure and the size of your estate. Build wealth and legacy. Creating a living trust is not just about managing your current assets, it's also about building a legacy. By establishing a trust, you can ensure that your hard-earned money benefits future generations. This might involve setting up funds for your grandchildren's education, supporting charitable causes, or creating a family foundation. A trust allows you to outline your values and ensure that your wealth is used in ways that align with your vision. Distribute your wealth wisely. In addition to creating a legacy, a living trust also gives you the power to control how and when your assets are distributed. This means you can set specific conditions or timelines for the distribution, ensuring that your wealth is managed responsibly. For example, you can arrange for your children to receive their inheritance at certain ages or milestones, or you can allocate funds for specific purposes like education or starting a business. Revocable versus irrevocable living trusts explained. There are two types of living trusts, revocable and irrevocable. As previously noted, a revocable living trust is the most common living trust and can be altered or revoked by the grantor at any time, making it a flexible option. This means you can adjust the terms of the trust as your circumstances or wishes change. On the other hand, the less common irrevocable living trust cannot be changed once it is established. This type of trust is often used for tax and estate planning purposes, offering benefits like asset protection and potential tax reductions. Essential considerations for setting up a trust. 1. Properly funding a revocable living trust. By understanding trusts and estates, you will realize that for a trust to be effective, it must be properly funded. Funding your living trust means transferring ownership of your assets into the trust. It's crucial to ensure that all relevant assets, such as bank accounts, real estate, and investments, are retitled in the name of the trust. Failure to do so can result in those assets not being covered by the trust, potentially subjecting them to probate. 2. Beneficiary designations. When setting up your trust, be mindful of how you designate beneficiaries on your accounts and insurance policies. Beneficiary designations can sometimes bypass the terms of your trust, leading to unintended consequences. It's important to align your beneficiary designations with your overall estate planning strategy to ensure a cohesive plan. How to set up a living trust. Setting up a living trust involves several steps to ensure your assets are managed and distributed according to your wishes. Here is a concise guide On how to start a living trust. 1. Determine your goals. First, clarify why you want a living trust. Common reasons include avoiding probate, ensuring privacy, and managing assets during incapacitation. Understanding your goals will guide the setup process. 2. Inventory your assets. Make a comprehensive list of your assets, including real estate, bank accounts, investments, and personal property. This inventory will be crucial for funding your trust later. 3. Choose a trustee. Decide who will manage your trust. You can act as the trustee while you're alive, but you'll need to appoint a successor trustee to take over after your death, or if you become incapacitated. Choose someone trustworthy and capable of handling financial matters. 4. Draft the trust document. Next, when you are ready to know how to create a living trust, you will consult with an estate planning attorney to draft the trust document. This legal document outlines the terms of the trust, including how your assets will be managed and distributed. An attorney ensures the document complies with state laws and addresses your specific needs. 5. Transfer assets into the trust. To make the trust effective, you must transfer ownership of your assets into the trust. This involves retitling properties, updating account beneficiaries, and changing deeds. Your attorney can guide you through this process. 6. Review and update regularly. After you have set up a living trust, review it periodically and update it as needed to reflect changes in your assets, family circumstances, or wishes. Happy planning!